Let me begin, first of all, with mentioning something which, although it is somewhat recent, as President Biden of United States mentioned while signing his executive order on competition law in 2021, they call it antitrust law, that capitalism without competition isn't capitalism, it is exploitation. So antitrust and competition in the market which is governed by open market forces or capitalism, it can turn into exploitation without competition. In October 1999, and mind you, at that time, the government had just come out with new economic policy, NEP 91, which under the then Finance Minister, Dr. Manmohan Singh, they had tried to create a system by which entrepreneurship in the country could flourish and the regulations and controls could be removed. So a committee was constituted under Mr. S.V.S. Raghavan to look at the situation and formulate a draft for a new competition policy and competition law. And this committee prepared a report which was quite elaborate, and the report was given out in 2000 and November 2000 to be precise, and a law was drafted which subsequently went to the Parliamentary Standing Committee, and the Parliament passed the bill in December 2002 to enact the new law, and the new law received the assent of the President on 13 January 2003 and became an act. Now, this was the beginning of the competition law called Competition Law 2002. But this was soon a challenge, and this challenge basically meant that they said that the MRTP was headed by a judge, and extensive powers were being given to this body, Competition Commission, and therefore this should also be headed by a judge and a number of other things. And there was a famous case of Brahmdat case, which went to the Supreme Court, and Supreme Court stayed the operation of the competition law, with the result that it continued to work with just a member at that time, and there was no chairman. Now, this was a situation when the government reviewed the entire matter in 2007, came up with an amendment in the law, which provided for establishment of a separate forum by the name of Competition Appellate Tribunal, which would be headed by a former Supreme Court judge or a retired Chief Justice of the High Court. And there were a number of other changes also. The Competition Amendment Bill 2007 was passed into the Act. And later on, this paved the way for smooth functioning of the Commission. And I was privileged, as I said, to be appointed as the first chairman. And unlike the MRTP Act, in the competition law, the chairman and members were to have been appointed by a committee headed by a judge of the Supreme Court. And I mean, they would recommend names to the government, and government would appoint. And that's the process by which the chairman and the members were appointed at that time in 2009. So I was sworn in on 28th of February 2009 at that time. And subsequently, all the members, 6 members, were also sworn in by me. Now, the enforcement began after the notification when the appellate tribunal was also constituted, because unless there was an appellate tribunal, there was no forum where the appeals could be filed. And this notification was issued for the appellate tribunal, and Justice Arijit Prasad was appointed, former judge of the Supreme Court, on 19th of May 2009, and 20th May, the functioning of the Competition Commission in enforcement began. And there we were at that time. We started receiving cases, and number of cases were filed. But there was not much of awareness at that time. In fact, people used to ask, what do you do? Do you conduct competitive examinations? So we had to undertake an extensive advocacy at that time to create awareness about what is the role of the Competition Commission in the smooth functioning of the market. In fact, one of my favorite quotes at that time when people used to ask, what is your job? So I used to say my job is to make markets function in the interest of consumers. In fact, if you look at the preamble of the competition law, the preamble itself says, and you must have read it a number of times, keeping in view the economic development. I'm reading it just to highlight a few factors, because the main objective of the competition law is to accelerate the economic development of the country. So the preamble reads, keeping in view the economic development of the country, for the establishment of a commission, and then the functions start to prevent having adverse effect on practices, adverse effect on competition, to promote and sustain competition in markets, to protect the interest of consumers, and to ensure freedom of trade carried on by other participants in the market. So these four limbs have been enshrined in the scheme of the competition law, and to prevent practices which distort the free functioning of the market in accordance with the principles of competition law. Section 3 is one pillar, Section 4 is another pillar. Section 5 and 6, which pertain to the BRA mandatory notification regime, suspensory regime, that until those kind of combinations which are above a certain threshold given in Section 5 and 6 are notified and approved by the Commission, they cannot be consummated, and the limits have been enshrined. Initially, there was a lot of resistance, if I can say, in notification of Section 5 and 6, and several sections of industry represented to the government that this would mean lot of negative effect on the flow of FDI in India, and combinations and acquisitions and mergers and so on, because there is another inspector or mother-in-law, as they used to call it, now been created, which would look at some of these M&A transactions. So I had to convince them there is a friendly mother-in-law, and this mother-in-law would be very keen to have another daughter-in-law in the household. And what we did at that time, I still remember the conference which I addressed in Mumbai at that time. So what I told them that we'll introduce a system of pre-merger filing consultation, PFC, and we would give guidance to the parties how to file, and we would approve it at least 95% within 30 working days. And in fact, we coined a term at that time that our effort would be file, smile, and go for the M&A. Still, with the advocacy across the country in all concentrated areas like Mumbai, Kolkata, Ahmedabad, Hyderabad, Chennai, and so on. After addressing industry in all these centers, we were able to convince them, and finally the notification under Section 5 and 6 was issued. And the enforcement of combinations, the M&A, commenced in June 2011. By the way, this was a factor which you might have read somewhere already, that during the CCI's consideration of cement sector, when they found that when there was an extensive demand for cement in the country, some of the cement companies, they decided among themselves to curtail production or the distribution, or sending their cement stocks to various parts of the country in order to create artificial storage artificial shortage and raise the prices. So those are the kind of things which are seen by the Competition Commission, and deterrent action is taken in such cases. In that matter also, the cement companies deterrent fines or penalties were imposed on them, and it's going on still before the Supreme Court. But they haven't got much relief. They had to deposit 10% of the penalty imposed for them. Or share the market and sources of production, provision of services by allocating a geographical area of the market. So this is again an anti-competitive situation, or result in bid rigging or collusive bidding having appreciable adverse effect in the market. This is also extremely important because government is one of the main buyers in the market, and almost 25 to 30% of the government's expense, both center and states, is spent in purchasing goods and services from the market. And if there are collusion in supply of goods and services to the government, it results in wastage of public money. And therefore, the Competition Commission, as also the Act, provides for very severe penalties in such cases. And by the way, CCI in its advocacy function, which is under Section 49, it has come out with a number of number of manuals how to prevent such collusive bidding, and it's a very detailed and very useful document which has been prepared by the Commission. Now, these were the horizontal agreements, and there are vertical agreements which cover various stages or levels of production chain in different markets, in production, distribution, storage, sale, or trade in goods and services. And there could be various distortions like tie-in arrangements or exclusive supply arrangement or exclusive distribution arrangement, refusal to deal, resale price maintenance, and so on. And by the way, you might have heard that there was a case of Maruti when the Commission held that they were guilty of violation of these provisions with their dealers, and they imposed heavy fines on them. Then there are certain exclusions under the Act in order to promote technology or intellectual property rights. So rights accrued under the Copyright Act or Patent Act, etc. There is a carve out, and these are excluded in such agreements. And of course, there are a number of refined agreements at that time, where one has to say that at times it is also necessary to see that some of these patents and intellectual property rights are essential for the public in general. And then the Commission expects that they would be framed, as they call it, fair, reasonable, and non-discriminatory terms evolved for giving such rights to other players in the market. Now, if the Commission comes to the conclusion that there have been violation, as I said, under Section 3 or 4, the Commission can, under Section 27, take action against the parties delinquent in such matters, and they can pass an interim order during the pendency of the inquiry for investigation, or under Section 33, they can even pass interim orders stopping further action. They can serve a cease and desist notice directing the offending parties to a cartel, and order the offending parties to modify the agreement. And there is a section 28, which is very important and very interesting, where the Commission has got powers to even break open and they can break the agreement, and they can say it will not be allowed to proceed under that agreement. And I use that particular clause, section 28, in trying to convince the industry in various centers. As I said, I addressed them, that if party A, which was otherwise going to enter into agreement with party B, if instead it acquires a party B or enters into a combination with party B, then what can happen if there is no provision of review or approval? Then Commission would have powers under section 28 to break open the agreement and say that it is illegal. And then there would be a situation you will have to like unscramble the egg. And therefore, it is in your own interest that there is a legal certainty. And if the Commission is saying that they would approve it, and so far they have not blocked any case, so they would approve it within 30 working days. In fact, most of the cases which have come before CCI, almost 900 of them so far, they have been approved almost 90 to 95% within 30 working days. So they have stuck to the initial promise, which they did. So that's what we try to do. The Commission also has powers under the Act to impose hefty pecuniary penalty on individuals also, each member of the cartel, also the members who were active at that time, they can be hauled up personally. And it has happened that hefty penalties have been imposed on them, the directors of the companies or the executives of the company. Abuse of dominant position was something which came up very frequently before us. And the abuse can be of various kinds. It could be exclusionary or it could be exploitative. And some of the initial cases that we received in the Commission at that time, there was in the real estate DLF case, and then there was the National Stock Exchange case when the MCX, they filed case against them and we held National Stock Exchange guilty. In the abuse of dominance, and this is important to know, that the main difference between MRTB Act and the Competition Act is that competition law does not frown upon the bigness or the dominance, but they frown upon the dominance. So if you are big, if you are elephant, you are not supposed to trample others in the market. So there should be no abuse. And for the abuse also, the elements have been described in the competition law: imposing unfair or discriminatory conditions in the purchase of goods and services, imposing unfair discriminatory conditions in the sale, including predatory price. Predatory price is again something very interesting. If somebody is trying to sell goods or services below the cost with an intention, and this is important, that the intention is to exclude your competitors out of the market or drive them away from the market. So that intent or intention is important to hold that a firm is guilty of predatory pricing. And there are other elements for the abuse: limiting or restricting production of goods and services, and or scientific development, or denying market access to anybody. Like, could be you may not like to deal with a person because you are very dominant and you don't want him to flourish. There are some other interesting provisions under the competition law. For example, the Commission has got powers under section, in fact, mandate under section 18 of the Act, because it says it shall be the duty of the Commission to eliminate practices at having adverse effect on competition, etc., etc. So Commission is duty bound, and therefore Commission can act suo motu even if there is no complaint. So they don't call it complaint, they call it the parties come and give notice that there is a situation like this, but Commission can act suo motu, and they have acted suo motu in a number of cases. One other factor which I would like to bring to your notice is Section 32 of the Act, which gives Commission powers to look at the agreements and situations outside India. And in fact, in the new competition, the competition amendment bill, which is lying before the Parliament, it is envisaged that the Commission would look at the global picture, if anything is happening outside India also. But the concerned enterprise has got presence in India or links in India, which can be affected by the result of that combination. So the Commission can look at that combination outside the Indian shores also. Under Section 49 of the Act, as I was referring to, the Commission has got an important mandate to undertake advocacy, and they have taken competition advocacy in several ways, producing various brochures and guidelines, etc., but also undertaking market study reports. So this is something which they have done extensively. For example, they conducted a market study on e-commerce. How are they functioning and what is the impact? And this came up in 2020 January. And then there have been other market studies in telecom, market study in pharmaceutical sector. And these market studies are extremely important and be useful for you to go through at least the summary sections, which also bring out the ways by which some of these companies in these sectors, they indulge in anti-competitive behavior.